I'm moving right on to the next item of business, which is a debate on motion 231363 in the name of Michael Russell on UK withdrawal from the European Union Continuity Scotland Bill. Can I ask those members who wish to speak in the debate to press the request to speak buttons now? And I call on Michael Russell to speak to and move the motion. Cabinet Secretary, please. It's been that kind of an afternoon. Cabinet Secretary.
My apologies, Presiding Officer. I thought I'd contribute my own kerfuffle as I didn't see the earlier one. Presiding Officer, let me start with a truism which, however, needs to be repeated regularly and often. The people of Scotland voted overwhelmingly to remain in the European Union, but are being dragged out of the EU against their will. Moreover, the people of Scotland have, in subsequent elections, comprehensively rejected the hard Brexit ideology of the Conservative Party and their plans to remove Scotland from the many benefits of EU membership, including membership of the single market and the customs union. The Tories in government in the UK, though in perpetual opposition here, are not listening. But the Scottish Government, and I believe this Scottish Parliament, is listening. We hear the ambition of the people of Scotland to retain the closest links with the EU to continue to meet the high European standards which presently serve us so well. And this bill makes a start, at least, in meeting those ambitions. It's a modest measure, but it will be of use to every part of our country and every sector of our economy. The only people who oppose it are those who have got us into this mess in the first place. This bill returns the ability to regulate lost as a result of the Brexit that Scotland rejected. It replaces the protection for Scotland's environment provided by EU law. It is a statement of our values and of the path we believe is the best future for Scotland. Now, my remarks on it will focus on part 1 of the bill, and my colleague Rosanna Cunningham will cover part 2, which is a particular focus in her area of responsibility. Let me make some progress, please. I want to thank the Finance and Constitution Committee, the Environment, Climate Change and Land Reform Committee and the Delegated Powers and Law Reform Committee for their thoughtful contributions to scrutiny of the bill so far, and also everyone who has expressed their views. And if Mr Fraser wishes to express his views, he may.
Murdo Fraser.
I'm grateful to the Cabinet Secretary for giving way. It was stated in evidence to the Finance and Constitution Committee that this bill creates a substantial Henry VIII power, taking power away from this Parliament and giving it to Scottish ministers. The Cabinet Secretary would be apoplectic if the UK Government were to do this. Why is it all right for him?
Cabinet Secretary.
I would be in a state of permanent apoplexy if I thought about the amount of that is done. Well, I am only in a state of permanent apoplexy because I'm faced with people like Murdo Fraser too often, I have to say. I would be in a state of permanent apoplexy if I even thought about the powers that the UK Government was taking to itself on a daily basis, today, in the House of Lords, in the Internal Market Bill. So please, do not patronise this chamber by pretending there is an interest in the powers. The powers are being grabbed by the party of which Mr Fraser is a member. Let me make some progress, however. Let me not be distracted by Mr Fraser. It's never a pleasant experience. A defining feature of this Parliament, in contrast to some others, is the importance we place on listening to those affected by what we do. Now, the power in Section 1 is intended to give ministers an appropriate way to recognise in domestic law the high standards represented by EU law. And I have, of course, heard the calls for greater clarity on the principles which underpin how this power will be exercised. I agree with those who say that the nature and breadth of the EU law makes trying to define these in the bill almost impossible. But I will commit, if the bill passes stage 1 today, to publishing guidance on the factors ministers will have to consider. I've also heard calls for the Parliament to reflect on the role it and stakeholders should play in scrutinising regulations. And of course, this is an important issue in every bill. Some have suggested that primary legislation should be required instead. Of course, there's a role for primary legislation in areas of major innovation. But to make all legislative changes, however small and technical, through primary legislation would be and always is disproportionate. I give way.
Liz Smith.
Can I thank the Cabinet Secretary and entirely agree with the points that he's just raised. Does he accept, however, that when it comes to major policy issues, primary legislation is very important?
I am always happy to agree with the reasonable face of the Conservative Party, which, of course, I have just heard. So, we will, of course, make sure that when there are major changes, they are adopted in that way. But attempting to limit the power to exclude significant new proposals wouldn't be practical, given the legal difficulties in defining those. Again, subject to Parliament's agreement, however, I'll engage further to agree a way of working together which identifies not only the point that Liz Smith has made, but gives Parliament an earlier role as possible. This could involve regular reporting by ministers on forthcoming EU legislation and its interaction with devolved areas, as well as a discussion on the most appropriate procedure for any legislation. I will also bring forward an amendment requiring ministers to make a statement to accompany regulations under this power, setting out the consultation which has taken place with local government and others. And finally, we have listened to those who are concerned that Brexit threatens human rights. With Parliament's agreement to the general principles of the bill, I will bring forward an amendment to require a further statement to accompany regulations explaining any effects on human rights. Presiding Officer, the people of Scotland did not choose Brexit. They certainly didn't choose as a sort of disastrous no-deal Brexit, which is still a real possibility, nor did they choose the equally bad low deal, which is the only alternative left on the table. That low deal is a painfully thin, job-destroying, ideological muddle, which, if imposed in the middle of a global pandemic and deep recession, will cost every one of us dear. It beggars belief that any responsible government would even consider it, still less choose it. This government will do all we can to ensure we remain a confident, outward-looking country, sharing values with the people of England, Wales and Northern Ireland, as well as with our European neighbours, valuing our joint commitment to human rights, compliance with international law and the protection of the environment at its core. And with that, I shall pass over to Rosanna Cunningham, the Cabinet Secretary for Environment, Climate Change and Land Reform, who will speak to Part 2 of the bill.
Well, it's breaking news to me, but it's been one of those days, call on Rosanna Cunningham, Cabinet Secretary, to speak to and, I presume, move this motion.
A unique job share for the Parliament, Presiding Officer, and can I thank Mike Russell for so clearly restating that Scotland did not choose to leave the EU. There should be no need to consider how to deal with exit, and anything we do cannot fully substitute for the loss of membership. From the beginning, my priority has been to protect our environmental standards in Scotland. I'm proud of our environmental record in Scotland and our commitment to respond to the global crises of climate and biodiversity loss. Our natural world supports our well-being and our reputation as a nation. Natural resources contribute to our society and economy in countless ways, and we must protect these precious assets from the threats arising from Brexit. In response, I committed to maintain or enhance our environmental standards. I have made clear that we should align with future developments in EU standards wherever possible. These objectives have been shared by many across Scotland in our public bodies, in our nature charities and across society. That is the context for the development of the environmental proposals in Part 2 of this bill. We have already completed a huge body of work to ensure that our regulatory systems are robust and will continue to protect standards. And earlier this year, I published our Environment Strategy Vision and Outcomes that will set a framework for future policy. The measures in this bill provide for continuity in domestic law of two key features of the EU structures that we are losing to ensure that we can continue to protect environmental standards. The proposals establish in domestic law guiding environmental principles. This will ensure that the principles continue to underpin the development of our environmental policy and law. The proposals will also create a proportionate system of domestic environmental governance to replace the role of the EU institutions in ensuring environmental law is fully implemented and effective. And this is becoming urgent. I hardly need to remind the Parliament that the Scottish Government made repeated calls to negotiate an extension to the transition period in the face of COVID-19, calls which were ignored by the Government at Westminster. So I'd like to echo Mike Russell's thanks to the Finance and Constitution Committee, the Environment, Climate Change and Land Reform Committee and the Delegated Powers and Law Reform Committee for their scrutiny of the bill to date. I'd also like to thank all those who have contributed their views. I think that with the hard work of the committees of the clerks and of stakeholders willing to give evidence remotely, the proposals in the bill have had a thorough airing. I appreciate that we have been working to a tight timetable for what are complex provisions But as I've already said, this is not a situation or a timescale of our own choosing. If people are saying that the proposals are not as good as being in the EU, I readily agree. However, we do need to be careful that in seeking to maintain what we are losing with EU exit, we keep the balance right with domestic law and procedures. So yes, we want to maintain what we had within the EU, but careful thought must be given to how best to translate supranational arrangements to that domestic law. As Mike Russell said, it must be for this Parliament to determine our environmental standards out with the EU. He made a clear argument against an automatic or rules-based application of the alignment power, and the real-world policy environment is just too complex to make a sensible set of rules by flatly applying criteria. There is a similar case to be made with respect to Part 2. We need measures to continue the effect of environmental principles and governance, but no rigid set of rules that can replace the judgments to be made by ministers. There is no rigid set of rules that can replace the judgments to be made by ministers and Parliament about future policies and legislation. The environmental principles must remain what they are in the EU context, a central guide to good decision-making to be weighed alongside other matters and objectives. Environmental governance must keep public authorities in line with the laws passed by this Parliament, but must not shift decision-making from this Parliament to another body or to the courts. And of course, I'll be flexible at stage 2. But I do believe that the fundamentals of the measures in the bill are what we need to have in place. There's limited time. We must focus on putting in place effective and proportionate principles and governments now, dealing with other matters at a more appropriate time. And I see the presiding officer is telling me that I have run out of the time that I thought I had.
Yes, well, it's been a mystery tour for us all this afternoon. There's 10 minutes for the Cabinet Secretaries. You've not moved the motion, please.
The motion in my name.
There we are. We're all inventing the script as we go along. I now call on Bruce Crawford, hopefully, on behalf of the Finance and Constitution Committee. 7 minutes, Mr Crawford. Convener.
Well, thank you, President Officer. I hope I can clear up any mysteries that may remain. But let me commence by very much thanking our clerking team in supporting the committee so effectively through the Stage 1 process. So too, let me thank my MSP colleagues for the way they went about the process. Yes, on occasions, not agreeing, but being able to do so amicably and with professionalism. President Officer, as lead committee, we focused on Part 1 of the bill. The Environment, Climate Change and Land Reform Committee focused on Part 2 of the bill. The convener, Gillian Martin, will discuss the findings of her committee later in the debate. Part 1 of the bill would enable ministers to make provisions in secondary legislation to keep pace with EU law in devolved areas where appropriate. My committee, with the exception of our Conservative colleagues, supported the principle that the keeping pace power as it exists in the bill. But the committee does not accept the use of the power should be entirely at the discretion of the Scottish Government. The committee recommends that the bill should be amended to require the Scottish Government to provide guidance, setting out the criteria which will apply to the use of the power. The guidance should also clearly set out how the keeping pace power interacts with other sources of regulation, which will impact on people and businesses in Scotland. This should include the impact of trade deals, common frameworks, and the operation of the UK internal market. The committee welcomes the commitment from the Cabinet Secretary to work with the Parliament to agree an appropriate and proportionate decision-making framework for future alignment with EU law, and therefore pleased the Cabinet Secretary is committed to publishing such guidance. But given the future governments may not always be as so accommodating as the current one, there may be still some room for further discussion on this matter. It's now therefore essential that the Parliament gives serious consideration to the level of scrutiny of the keeping pace power, which would both appropriate and proportionate. Specifically, what role should the Parliament stakeholders and wider public have in relation to both the decisions on whether or not to keep pace and early engagement in the policy development process, especially where there are opportunities for ministerial discretion and how to keep pace. The committee recognises that until now Parliament has had a very limited role in relation to EU policy development process. And there may be a potential risk that EU policy making process is replaced by executive-driven process, which allows for significant levels of ministerial discretion. Therefore, there is pressing need for the Parliament to consider how its scrutiny role needs to evolve to meet the challenges of the impact of Brexit on devolution. The committee is therefore agreed to write to other parliamentary committees seeking their views on this matter. We also requested a committee debate in the Chamber before Christmas recess, and would encourage all committee conveners or representatives from each committee to speak in that debate. Presiding Officer, a key question for the committee is whether the extent of the secondary powers in the bill are appropriate. As colleagues will be aware, the keeping pace regulations in the bill are subject to either the affirmative or negative procedure. The committee recognises that it may be necessary and indeed acceptable for minor and technical amendments to be made quickly for subordinate legislation to refine retained EU law. However, the committee recommends that further consideration is needed in relation to implementation of significant new policy proposals that have no equivalent in retained EU law. The committee therefore recommended that the Scottish Government give serious consideration to the DRPRC's view that primary legislation is the most appropriate vehicle for domestic law to implement significant new policy proposals that have no equivalent in retained EU law, and that this applies particularly to EU directives. And in the event that the power is not amended to that effect, the committee recommends as the choice of procedure is expanded to include super affirmative procedure. I note the Cabinet Secretary's view that attempting to limit the scope of power in Section 1.1 to exclude significant new proposals would not be practical given the significant legal difficulties involved in defining that on the face of the bill. I also note the Cabinet Secretary has said he's content to discuss this matter further. Presiding Officer, a further important consideration for the committee, and indeed the Parliament, is the extent to which the keeping pace power may be subject to statutory and non-statutory constraints. While in principle, the keeping pace power is very wide, in practice, it may be much more limited. In particular, although my Conservative colleagues disagree, the committee notes that the mutual recognition and non-discrimination principles in the UK Internal Market Bill have the potential to significantly undermine the use of the keeping pace power. Indeed, the committee believes that the Internal Market Bill and the market access principles in particular undermine the whole basis of devolution. This Parliament has made its views clear in refusing consent for that bill. This leads me to my final point, Presiding Officer, which is the role of common frameworks, an area which the committee has considered extensively. The committee remains very supportive of the Scottish Government's view that common frameworks should not be imposed by the UK Government. The committee supports a system of common frameworks for trade in the UK market, the common frameworks to be agreed between devolved governments and the UK Government. However, it is also equally important that common frameworks are not effectively imposed on the Parliament and stakeholders without meaningful consultation and opportunity to propose amendments. Therefore, in conclusion, Presiding Officer, the committee, with the exception of my Conservative colleagues, supports the general principles of the bill. Thank you.
Thank you very much, Mr Crawford. I now call on Gillian Martin on behalf of the Environment, Climate Change and Land Reform Committee. Convener, 6 minutes, please.
Thank you, Presiding Officer. I speak today as the convener of the Environment, Climate Change and Land Reform Committee. The committee has outlined a number of areas where further information and action is required in relation to Part 2 of the bill. The committee has previously highlighted its serious concerns about Scottish ministers' ability within the devolution settlement to exercise their powers in devolved environmental competence following EU exit. In fact, I made a statement from the committee in the summer on exactly that point in relation to our discomfort on giving approval to a legislative consent motion on the UK Environment Bill, and that's just one example. The Continuity Bill and its interplay with the UK Internal Market Bill raises further questions around the broad and lasting consequences of EU exit, including on the development and agreement of common frameworks. Common frameworks which, despite our continued asks for more detail on from the UK Government, certainly in the time that I've convened the committee, we've yet to receive sufficient information on, and my committee agrees with the Finance and Constitution Committee on that point. The committee does agree that the general principles of Part 2 of the bill, and insofar that it seeks to provide legal recognition for the environmental principles and oversight of the implementation of and compliance with environmental law following EU exit. We welcome the Cabinet Secretary's determination, outlined again today, to keep pace with environmental standards set by the EU. However, we do want to highlight some concerns, in particular around the role of environmental principles and the functions, powers and independence of the proposed new Environmental Standards Scotland, or ESS. The committee certainly supports the commitment to maintain or exceed EU environmental law to ensure the continuation of higher environmental standards in Scotland, and we believe that this bill is fundamental in consolidating the framework for environmental law and other policy and law which impacts on our environment. And I apologise for the noises off. I'll keep going. On balance, we are content that the keep pace power is discretionary, but we also think there needs to be a more clarity over when the Scottish Government would use the regulation-making power under Section 1. We're also of the view that the climate and ecological emergencies, climate targets, commitment to maintain environmental standards and sustainable development must form part of any decision-making tools or assessments when deciding whether to keep pace. We have made the recommendation that the Scottish Government regularly reports to Parliament on developments in EU environmental law, on how this has been matched in Scotland, and it's crucial we have a transparent and accountable process for parliamentary engagement and scrutiny on those decisions. The Scottish Government should also lay a regular report to Parliament on significant developments in international environmental protection legislation. We welcome a statutory footing for the principles in the bill, but we believe in order to provide legal continuity, we also need to set a high level of environmental protection. Without this being on a statutory footing, this Scottish Government's objective to achieve a high level of environmental protection is a statement of their policy intention, and we believe this does not necessarily provide legal continuity for any subsequent governments. We firmly believe that in order to deliver a green recovery and respond to the climate and ecological emergencies, we need to integrate environmental issues across all government policy and legislation. This will rely on having a legislative basis to the principles of integration, environmental equity, and extend the precautionary principle to include human health. We've said in our report that we need to know how these principles will sit in the broader constitutional and legal context and how they will be applied. We also need further information on how the UK Internal Market Bill will influence Scottish ministers' ability to act on the environmental principles. Let me now turn to Environmental Standards Scotland. We asked whether this body will provide continuity of environmental governance, and we heard there are potentially a couple of governance gaps, specifically in the ability to pursue matters at the level of an individual case. The investigation of cases where the environment is an element, but not the core of the matter, and in climate governance more generally. Under the proposed system, an element of government previously fulfilled by the European Commission is now ultimately going to end up in Parliament through the lodging of an improvement report, and this will impact parliamentary committees, particularly ours, when we question the capacity and access to expertise of committees to consider such reports. There's a long-standing debate also about the need for an environmental court in Scotland, and we have flagged this in our report. We need to rationalise how legal issues and appeals are determined across regulatory frameworks affecting environmental issues, and we firmly believe that compliance appeal cases need to be heard by people with the expertise and experience in environmental law. We're keen to know how the Scottish Government plans to build and consolidate environmental law expertise across the judiciary in tandem with setting up of ESS. In conclusion, Presiding Officer, the committee was of the view that the bill's success from the point of view of the environment depends on a satisfactory response to the issues we've raised in our report and strengthening in the areas we've outlined, But as I said earlier, we support the principles at this stage. Thank you, Presiding Officer.
Thank you, Mr Martin. I'd also like to thank your canine companion for little interventions made on your behalf, or perhaps not on your behalf. And now call on Dean Lockhart. Let's hope this goes just smoothly for this afternoon. 6 minutes, Mr Lockhart.
Thank you, Presiding Officer. I don't have any pets with me as far as I can see. Let me add my thanks to all the hard work of the clerks, conveners and the others in the various committees overseeing this legislation. The context for this debate is that Scotland is now facing an unprecedented recession, with the economy declining by 20% and unemployment increasing rapidly. And following the additional restrictions announced earlier today, the priority for this Parliament must be to protect jobs and livelihoods and rebuild Scotland's economy. Instead, however, we are debating a continuity bill that will do the opposite, a legislation that will impose barriers to trade, increase the cost of doing business and ultimately, I'm afraid, cost jobs and livelihoods across Scotland. Because there's no doubt this legislation will damage Scotland's trade with the rest of the UK and beyond. And those are not just my views, those are the concerns raised by stakeholders giving evidence to the Finance and Constitution Committee. I will, in a minute, was that Mr Mason? I will in a minute, Mr Mason. According to the NFUS, for example, the keeping pace powers in Part 1 of the legislation has, in their words, the clear potential to lead to substantial regulatory and economic divergence with the rest of the UK, which for them is a major concern, given that over 60% of Scotland's agriculture and food exports go to the rest of the UK. And these concerns are not just limited to agriculture, because according to the Fraser Founder, more than 550,000 jobs across all sectors in Scotland depend on that barrier-free access to the UK internal market. And I will give way to the Cabinet Secretary.
Cabinet Secretary.
I wonder if the member has read the submission from the NFU to the Internal Market Bill, which talks about the difficulties that will be experienced by the Internal Market Bill and those proposals being made and the effect they will have on trade. Would it not be better to remain in the EU, which gets rid of all these problems? And that would help all of us. And that would mean that the recession that we are facing would not be made worse by Brexit, because it will be.
Dean Lockhart.
Well, Cabinet Secretary, we're debating the EU Continuity Bill today. And when it comes to the internal market, as we have debated before, common frameworks will form the bedrock for the internal market trade, and it was unfortunate that you walked away from negotiations on the internal market guidelines. Presiding Officer, by keeping pace with some, but not all, future EU laws, this legislation will require firms in Scotland to comply with a myriad of divergent regulations, including devolved law that keeps pace, devolved law that does not, and different regulations in other parts of the UK which no longer follow EU regulations. The committee heard evidence that this will lead to Scotland becoming a regulatory no-man's land, with the inevitable consequence of these proposals that it will increase the expense and complexity of doing business, increase costs for consumers, and at the end of the day, cost jobs and livelihoods, all at a time when thousands of businesses across Scotland are already struggling to survive under COVID restrictions. But, Presiding Officer, the ultimate indictment is that this legislation will not even achieve its stated aim of keeping Scotland aligned with EU regulations, as the Cabinet Secretary mentioned in his opening remarks. The Faculty of Advocates has pointed out that the Scottish Government will not be able to keep pace in areas of EU law which depend on reciprocal arrangements between member states. And commenting on the proposed legislation, EU officials have said the following: this legislation could create a difficult position for Scotland and wouldn't be effective. Many regulations which are passed by the EU will be difficult to implement and will not apply to Scotland. So I look forward to the Cabinet Secretary addressing this EU response in his closing remarks. But, Presiding Officer, this bill will not only damage Scotland's economic recovery, it also represents a power grab by Scottish ministers, which will undermine the powers of this Parliament and turn it into a passive rule-taker of future EU laws. And the SNP members commenting should listen to the following concerns raised by key stakeholders. Paragraph 48 of the committee report refers to the keeping pace powers, and I quote, as substantial Henry VIII powers. In other words, powers which will enable Scottish ministers to introduce new laws, including significant new policies, by means of secondary legislation without any parliamentary scrutiny or consultation with stakeholders. Our concerns in this area are shared by the Law Society of Scotland, the Faculty of Advocates, the NFUS and a number of constitutional experts, including Professor McHarg, who gave the following evidence to the committee. In these circumstances, it seems very hard to justify putting such an extensive power into the hands of Scottish ministers. And, Presiding Officer, we agree, as does the NFUS, who told the committee there is an absolute requirement that Scotland, through the Scottish Parliament, retains an ability to adapt new laws for Scottish circumstances. And, Presiding Officer, I've read the Cabinet Secretary's response to these stakeholder concerns, and I've listened to what he has said today about some of the amendments he will bring forward at stage 2, and I have to say he provides no assurance whatsoever in respect of this Parliament having the proper level of scrutiny. And given these concerns I have outlined, a number of stakeholders have provided recommendations on how this legislation can be improved. For example, the NFUS making the following important recommendations: that ministers be required to publish a full regulatory, financial and environmental impact assessment of regulations made under the legislation, and to ensure that all keep pace regulations are made following consultation with relevant stakeholders. We will be listening to those recommendations of the NFUS and other key stakeholders, and we will be bringing appropriate amendments at stage 2 to address these concerns. Presiding Officer, let me conclude. We will be voting against this legislation at decision time today. It gives excessive powers to Scottish ministers to implement significant new policy changes with no parliamentary scrutiny. It will turn this Parliament into a passive rule-taker, and it will create barriers to trade between Scotland and the rest of the UK, a market that accounts for more than 60% of our trade.
Thank you very much. I now call Alec Rowley to be followed by Mark Ruskell. Mr Rowley, please.
Thank you, Presiding Officer. I'm pleased to be speaking in this Stage 1 debate today on the Withdrawal of the European Union Continuity Scotland Bill. At the outset, I would like to thank the hard work of all on the Finance and Constitution Committee and the Environment, Climate Change and Land Reform Committee, who have done the work to scrutinise the bill, particularly the support of the clerks in bringing together the Stage 1 reports. I would also like to take the time to thank all who gave evidence and helped advise the committees through the scrutiny of this bill. The bill is being brought forward to allow our legal system to be able to keep pace with EU law in devolved areas where appropriate, as well as being able to ensure that there continues to be guiding principles on our environment here in Scotland and our post-Brexit landscape. These general principles are supported by the Labour Party, and we will be supporting the government with the progression of this bill today. Our view is that at this stage we agree in principle with creating new powers to allow the government to keep pace with EU laws. It is particularly desirable to be able to deliver the strong environmental standards we want to see in Scotland. It would be impractical to require all changes in EU law to be given effect by primary legislation in the Scottish Parliament. This would hold up important legislative activity. However, some future changes in EU law could involve substantial policy considerations which Parliament and stakeholders must have the opportunity to scrutinise and influence. The Government must set out detailed guidance for how these powers would be used and alternative processes for when consultation is required. Scottish Labour welcomes the proposal of a new environmental governance body, Environmental Standards Scotland, but this has to be independent from government. We believe that climate change, individual cases and fiscal measures should all be included in the remit of this body, and that exemptions to investigations should be prevented or at least have to go through primary legislation. We welcome that the EU guiding principles are incorporated in the bill, as argued by Scottish Labour in the previous continuity bill. Labour are considering amendments at stage 2 to add further principles, including recognition of human health impacts. We also believe the bill should be strengthened at stage 2 to act in accordance with the environmental principles. The keeping pace powers should not be entirely at the discretion of the Scottish Government, and there must be greater clarity on how the Scottish Government proposes to use the powers. I am pleased by the indications from the Cabinet Secretary to the Finance and Constitution Committee that he intends to work with the Parliament to agree an appropriate and proportionate decision-making framework for all future alignment with EU law. I welcome his letter to the Finance Committee on Tuesday this week, which stated that he would commit to publishing the guidance which will be used to inform decisions on the use of this power. This is a welcome step, Presiding Officer. However, worth noting, moving forward with this bill, the Law Society of Scotland state in their briefing that it is suggested that the power to make regulations under Section 1 should be restricted to where the changes in EU law do not involve substantial policy considerations unless they are subject to super affirmative procedure. I think this point is worth bearing in note. From my reading of the Cabinet Secretary's letter to the committee, he appears not to have taken this suggestion on board, and I am hoping that an agreement can be made that satisfies the level of scrutiny that will be required before taking on board new rules in this country. The National Farmers Union have also said that they agree with the recommendations of both the Finance and Constitution Committee and the Environment and Climate Change and Land Reform Committee that use of the power in Part 1 of the bill should not be absolute and inflexible, and that there should be a stronger role for Parliament in scrutinising its use. So I do hope, Presiding Officer, that there will be a willingness to work together. We believe there is a need for this legislation. It is ludicrous for the Scottish Tories to continue to line up with Boris Johnson and attack the environmental rights of this Parliament and of the people of Scotland. So we will work together to ensure that at Stage 2 and Stage 3 we improve the legislation and put it through. Thank you.
Thank you. I now call Mark Ruskell, followed by Lee MacArthur.
Thank you, Presiding Officer. And can I say at the outset that the Greens strongly back the bill's principles at Stage 1, just as we backed the original continuity bill that was so recklessly struck down by the UK government. And while the storms gather over the internal market bill, it's important to forge ahead now with European alignment for the sake of the environment, people and our economy. I think it's also important, though, to reflect on what this bill aims to stay in alignment with, because European protections were built on the struggle of citizens' movements to protect human rights and the environment over many decades. From the Sandoz chemical spill that decimated the Rhine to killer air pollution in European cities to today's climate emergency, European protections have been the response to these struggles and now provide a strong counterweight to the economic neoliberalism that, if left unabated, would have collapsed Europe's environment a long time ago. Now, the committee was told that the primary objective of this bill is to maintain alignment with those hard-won protections, but also to ease the path to reaccession to the European Union. So it's not a pick and mix. It's not Norway light. It's about EU membership. And the bill at Stage 2 will be a test for the Scottish Government's commitment to that goal of alignment and reaccession. Now, the foundation stone to this, of course, is the keeping pace power. And I welcome the Government's commitment to making the decision-making framework around it more democratically accountable. But it still needs a direction. It needs a statutory purpose that actually nails what we are aiming for. One of the rights that we had as EU citizens was the right to enjoy a world with a high level of environmental protection. That's enshrined under Article 37 of the Charter of Fundamental Rights, yet it's absent from this bill. And if the government wants to maintain and exceed European environmental standards, then it needs to be clear in law that this means a high level of environmental protection. But I do have my doubts, because in the government's response to the Environment Committee Stage 1 report, it says, and I'll quote, "When enhanced environmental standards are introduced in the EU, we can expect a full and lively policy debate about how Scotland should respond." Well, that worries me, because while there will be EU laws that are no longer functionally relevant to a departed member state, there are those that set core environmental standards that will be. And actually, I don't want a lively debate about whether we should be holding off tackling air pollution that causes asthma in a child, or whether we should keep spraying a pesticide that decimates bee populations. What I want is European-wide action as the baseline, And on the 4 key environmental principles that the bill does attempt to enshrine, it only requires ministers to have regard to them. very different to how policy has been developed up to now within the EU, because EU treaties have required our policy to be based on these principles. This have regard to phrase has been judged by a Westminster committee to be weak, unenforceable and lacks clear meaning. So why put these weasel words into Scottish legislation? There is an opportunity, though, I think, to deliver real progress while staying on that parallel path to reaccession. Applying environmental principles to budgets, for example, would drive the green recovery that I think we all want. The precautionary principle would help put preventative spending first, stopping costly problems from becoming unmanageable in the future. Environmental Standards Scotland, if it is to replace the European Commission, needs to be strong, independent, well-resourced and rigorously appointed by Parliament. It needs to operate under the widest definition of the environment, including climate change. It needs to consider individual complaints as case studies to improve compliance with the law and to suggest changes to the law itself. ESS needs to be a watchdog that has one eye on the European and international legislation, with the other eye firmly focused to ensure that we're actually keeping pace at home. Presiding Officer, there is acres of room for government and a majority of MSPs in this Parliament, should they wish to improve this bill at stage 2. For the sake of our environment, our health, we need to continue to make progress in lockstep with our European neighbours, and this bill must rise to that considerable challenge.
Thank you very much. I now call Liam MacArthur. Then it will be the open debate.
Thank you, Deputy Presiding Officer. Can I start by thanking the Finance and the Clare committees for their work to date on this bill. It's not a bill many of us would have wanted to see, and certainly further highlights the needless damage, disruption and uncertainty caused by Brexit. As Scottish Environment Link point out, 80% of Scotland's environmental protections currently stem from EU legislation. The climate emergency and tackling biodiversity loss demand no let-up in robust standards, and so this is what we must look to achieve through this bill. To do this effectively, the approach must be based on the right principles and set it in the context of a clear overall purpose. And while I have no difficulty at all with the 4 principles that are currently in the bill, I agree with the Clare Committee and others that the Government should go further in including the Lisbon Treaty principles on high levels of protection as well as integration. It would also be helpful, I think, to set out that overarching principle. Scottish Liberal Democrats will work with others to achieve this at stage 2. Such principles only really matter if there is some onus on ministers to use them as the basis upon which to take decisions. And as Link pointed out, and Mark Ruskell's just identified, the bill going through Westminster appears to put in greater safeguards in this respect than what is currently proposed in this bill. Whether it's a requirement for ministers to have due regard to or act in accordance with, it's clear the committee wants to see the government toughen things up. And again, it's an area where Scottish Liberal Democrats will work with others to achieve this. Another problem which Stage 2 and the government will have to address stems from the power the bill gives ministers to keep pace while not actually requiring them to do so. Nobody else is allowed to insist that ministers keep pace. Only ministers can choose as things currently stand. I was struck that Mr Russell told the committee, quote, that those who are opposed to any keeping pace could frustrate the legitimate will of the Scottish people to keep pace with high standards. He then spent the rest of his time saying that he wasn't going to keep pace with everything for a whole series of reasons. So it turns out that he might yet find himself in the position of frustrating the legitimate will of the Scottish people. Now, the Law Society, the Faculty of Advocates and others have put forward suggestions about how this might be addressed. I know Professor Michael Keating put it well when he said we need to know on what basis things are going to be selected. There has been some suggestion of an annual report looking ahead to anticipate EU legislation and state whether government intends to keep pace. There are a variety of options. The Cabinet Secretary has referred to perhaps the use of guidance, but I think the bottom line is that this does need to be addressed again at stage 2. Other concerns flagged up by the committee include protecting the independence of Environmental Standards Scotland, and I can certainly understand those anxieties. But let me close by acknowledging one other issue identified by Link in their briefing. The case for a dedicated environmental court or tribunal is one that has been made by many people over many years, though perhaps few with as much persistence and passion as Lloyd Austin, formerly of RSPB. I think this bill does, though, allow an opportunity for the government at least to commit to consult on an environment court, allowing any incoming government in May to decide on how best to proceed. And I hope this is something that the Cabinet Secretary will consider and look to take forward, at least in terms of its initial steps. Meantime, again, I thank the committees again for their work to date and assure them of Scottish Liberal Democrat support in taking forward the improvements needed to minimise the damaging legacy of Brexit, particularly in the area of environmental policy. Thank you.
Thank you very much. We now move to the open debate, and I call Joan McAlpine to be followed by Liz Smith.
Thank you very much, Presiding Officer. We are now more than 4 years on from the disastrous and irresponsible Brexit referendum, so it's worth reminding ourselves of the outcome of that vote here in Scotland. Remain 62%, Leave 38%. Every single local authority area in Scotland voting Remain. So this legislation has an overwhelming mandate from the people of Scotland. It has been forced on us by the UK Government's actions, not just in taking us out of the world's largest single market, not just in ignoring compromise solutions from the Scottish Government, such as remaining in the single market and customs union, but also in refusing to extend the transition period despite COVID and despite failing to secure any kind of trade deal worth the name, certainly not the Canada double plus that was the UK's minister's catchphrase just a few months ago. The Tories have swung the wrecking ball of Brexit towards Scotland, Presiding Officer, and this bill aims to mitigate some of the destruction that wrecking ball will do. This is law as a damage limitation. Maintaining high environmental standards is critical for addressing the nature and climate emergencies that we face, as well as underpinning efforts to deliver a green economic recovery from COVID-19, which are all Scottish Government priorities. I note the Scottish Environment Link welcomed the bill's intention to embed the 4 EU environmental principles directly into Scots law. These are the precautionary principle, the polluter pays principle, the rectification at source principle, and the preventative action principle. And I note that Scottish Environment Link would like us to go further still, so instead of requiring ministers to have regard to the 4 principles, as the bill states, Link wish it to say that the policy will be based on the 4 principles. This strikes me, Presiding Officers, as a fine line, and no doubt colleagues will give it due consideration as the bill moves through Parliament. Presiding Officer, I must comment on paragraph 87 of the Finance and Constitution Committee's report, which refers to the UK Internal Market Bill and notes that the UK Internal Market Bill could significantly undermine the use of the keeping pace power in this continuity bill, and indeed is incompatible with devolution, as my colleague Bruce Colleague has said. Presiding Officer, my committee, the Culture, Tourism, Europe and External Affairs Committee, has also taken evidence on the Internal Market Bill, and we came to exactly the same conclusion. The Scottish Parliament has now voted decisively to withhold consent to the Internal Market Bill, but there is absolutely no reassurance that the UK Government will listen. That is why there is really only one way forward. This legislation will try and ensure we keep pace with European environmental standards, but it looks like the Brexit wrecking ball means that anything we do in this Parliament can simply be obliterated, and the devolution principle is turned to dust. That's why more and more Scots understand that only by assuming the full status of an independent country can we prevent them smashing Scotland's powers to pieces. That independent Scotland is coming, Presiding Officer, and it will be an independent, equal member of the European Union. The Continuity Bill will help ensure we are ready to rejoin Europe in as smooth a way as possible, and I therefore have no hesitation in supporting it today. Thank you very much.
Thank you very much. I now call Liz Smith to be followed by Tom Arthur.
Thank you, Deputy Presiding Officer. And just as was the case when we debated the UK Internal Market Bill a few weeks ago, Parliament's main purpose with regard to the end of the transition period must surely be to ensure that all the post-Brexit structures which will be put in place will ensure that we have the best interests of Scotland at heart, her relationships with the rest of the UK and, of course, with the international community, most especially those which protect the internal market and Scotland's ability to be a thriving nation in the future. So the Continuity Bill must be judged against these criteria. And I'm sure we can all agree, just as we did last August, that Scotland's best interests also have to have the principal concern for legislative perspectives. To this end, it's surely important that Scotland's governments work together and do not seek to create any division. And that is obviously true for the environment, just as much as it is true for other aspects of policy. And I think Rosanna Cunningham was correct when she said that we can all agree that it is essential that Scotland does not lose crucial environmental safeguards as the UK exits the EU. Safeguards which have increasing relevance as the focus on the environment becomes ever more prominent. But that brings me to the controversial principle about keeping pace. Because in the Continuity Bill, this principle is designed to ensure that in Scotland we will be aligned with EU regulations wherever possible. But that's something about which these benches are uncomfortable, because it would necessarily mean keeping pace with standards and laws over which we would not have any say. But there's another aspect to this too, and Bruce Crawford mentioned this in his opening for the committee, namely because any keeping pace decision would become a matter of political choice for ministers, rather than be a legally binding commitment, as was the case when we were in the EU. And potentially that invests significant powers in ministers and raises questions over the scrutiny of some key policies, as Alec Rowley pointed out. And the evidence to both the Environment and the Finance Committees reflects that. So with reference to Part 2 of the bill relating to the environment, there is general agreement across all the parties about the need for Scotland to adopt the highest environmental standards and for a legal basis to protect these environmental principles. But there is much less agreement about the structures which need to be put in place to achieve this. As the convener of the Environment Committee said, we have broadly agreed on some key principles that would have to be adhered to for the highest standards, for example, if the polluter pays, but we are not agreed about exactly how to do that. For example, some witnesses, especially Link and the National Trust for Scotland at the Environment Committee, were seeking confirmation that some aspects of EU environmental law should be written into the bill specifically, requiring ministers to keep pace with environmental standards. But that was definitely not the view of the National Farmers Union, who told the Finance Committee that they have long been frustrated by agriculture's inability to adopt the local circumstances as a result of some aspects of blanket EU law, which does not always articulate with local circumstances. And that, of course, is only part of the story, as questions remain about keeping pace decisions. I think, again, it was Bruce Crawford who raised the fact that this keeping pace issue has implications for trade deals, common frameworks, etc. So there are a lot of question marks over that. And it's for these reasons that these benches want to see structures put in place which permit maximum flexibility when it comes to achieving the highest standards. So it should not just be a case of aspiring to follow EU law, where there would be no guarantee that all EU standards would automatically be the ones that we wish to adopt. Secondly, we want to see good governance when it comes to parliamentary scrutiny and the agencies which oversee environmental standards. And I think there's a lot of issues that have been raised at both committees about how we do that. And I entirely accept the comments that have been made from others about Environmental Standards Scotland, which in principle I think is a very good idea, but whether it has sufficient independence from government and its ability to have a separation of powers, I think is a major issue within this bill. Deputy Presiding Officer, may I just conclude with reiterating the point that I made at the start, namely that the post-Brexit structures must put in place what is in the best interest of Scotland and the UK, both in terms of economic growth and social cohesion, and that both governments have to work together to deliver what is surely, and I think the public has the right to expect. Thank you.
Thank you very much. I now call Tom Arthur to be followed by Claudia Beamish.
Thank you, Presiding Officer. I am grateful for the opportunity to participate in this afternoon's debate. And I would like to put on record my thanks to committee colleagues, clerks and those who gave evidence. It is a matter of regret that this legislation is required. My constituents from Renfrewshire South, along with a clear majority of people in Scotland, opposed leaving the European Union. They registered that view in the referendum of June 2016 and reinforced it at subsequent elections, most recently at the UK general election in December 2019. With barely 5 months until the dissolution of this Parliament, current opinion polling suggests that support for the parties most strongly opposed to Brexit has only strengthened. The circumstances in which we find ourselves are a consequence of a monumental failure of statecraft by the UK government. Had they responded with humility and a sense of responsibility to the referendum and pursued a settlement commensurate, close and contested nature of the result across the UK, it could well have been the case that we would now be exactly 19 months to the day into a single market and customs union arrangement. Instead, we are exactly 9 weeks to the day away from at best a damaging no-deal Brexit and at worst a disastrous no-deal Brexit. Given that our best case scenario is now a hard Brexit, it is of the utmost importance that we respond by equipping ourselves with the necessary tools to mitigate and minimise the impact of the UK Government's hardline approach. This bill is an important part of that response, in particular by enabling Scottish ministers to make provision in secondary legislation to allow Scots law to be able to keep pace with complex EU law in devolved areas, where appropriate. Out with the European Union, Scotland will, of course, no longer automatically be subject to new EU regulations, nor will it be obliged to implement EU directives. That does not, however, preclude this Parliament seeking to mirror EU law where it determines that is appropriate. And I wish to stress at this point that it will be for this Parliament ultimately to decide whether or not to incorporate any new aspect of EU law into Scots law via this bill. All regulations in Part 1 of the bill are subject to the affirmative or negative procedure. Power remains with this Parliament. The Scottish Government can propose, but it is for the Parliament to decide whether to approve. For those who wish to see an example of Scotland being compelled to be a rule taker or for a hoarding of powers by the executive, one need look no further than the UK Government's Internal Market Bill. This UK Government legislation, which was comprehensively rejected by this Parliament only a few weeks ago, poses a threat to the bill we are considering this afternoon, something that was highlighted by the convener of the Finance and Constitution Committee, Bruce Crawford, who quoted from paragraph 87 of the Stage 1 report, and these words bear repeating. The mutual recognition and non-discrimination principles in the UK Internal Market Bill have the potential to significantly undermine the use of the keeping pace power in this bill. Indeed, as the committee states in our report on the Internal Market Bill LCM, we believe that the Internal Market Bill and the market access principles in particular undermine the whole basis of devolution. Presiding Officer, this state of affairs serves as yet another example of the inadequacy of the current constitutional arrangements. The best solution would be for Scotland to be a member of the European Union in its own right. However, as we face the imminent end of the transition period, we must do all that we can to ensure that we have the flexibility to retain the closest possible alignment with the EU where appropriate. It is on that basis that I support the general principles of the bill.
Thank you very much. I now call Claudia Beamish to be followed by John Mason.
Thank you very much, Presiding Officer. The Continuity Bill is fundamental to our devolved settlement as Brexit deadlines sadly approach all too fast. The bill is introduced and the scrutiny so far afforded by both committees is significant. I intend to focus, though, on some of the concerns raised by the Eclair Committee in our Stage 1 unanimous report, which I do not believe have yet been resolved by the Scottish Government response. We need to have the most robust possible protection for our environment and scrutiny of all actions and impacts by air, land and sea. This is not simply because of this government and its commitments, but about underpinning future Scottish Government's direction and accountability. I was delighted when the Scottish Government agreed to enshrine the 4 EU guiding principles: precautionary, prevention, rectification at source and polluter pays in law in the previous struck-down continuity bill due to amendments by myself and Mark Ruskell. I still ask the Scottish Government to consider if it would be necessary to refer explicitly to human health in the precautionary principle with an amendment due to the importance of assessing how actions affect our human health. The 4 principles being focused on, as it is, I also think that it's necessary to have a high-level environmental protection principle on the face of it, as in the Eclair Committee report, Recommendation 81, reflecting the treaty and functioning of the EU, on the functioning of the EU. I also want to focus our thinking on the integration principle, which I believe would strengthen the bill. In recommendation 83, we state, as our convener quoted, the committee believes that in the light of the green recovery and the current climate and ecological emergency, it is critical that environmental issues are integrated across all government policy and legislation. Despite what the Scottish Government says in response to our report, that there are references in the bill, I'm still of the view that there is a need for a standalone integration principle for robustness, and I hope it will reconsider. Have due regard to, or act in accordance with the principles. I actually am aware that time today prevents me from going into the detail of committee stakeholder engagement and our deliberations on these significant differences. It's disappointing, though, that the Scottish Government does not agree with our committee recommendation and has said in its response that, I quote, have regard to, rather, would give effective and proportionate effect to the principles. It is crucial that we accord these principles the strength that is similar to or greater than at present in the terms of the EU treaty. Thus, I ask the Scottish Government to reconsider. Turning to the new body, ESS, our environmental laws are only as good as the institutions which uphold them, and a watchdog can only be robust and effective if it is truly separate and independent of government. The European Commission's role in implementing and enforcing environmental law has been crucial, and this is because of its independence from Member States' national governments. I still think climate change should be included in the remit, despite the Scottish Government reassurances. And now to exclusion of individual decisions. Unless these limitations are removed, the ESS will not provide the continuity with existing EU arrangements and would represent a significant erosion of environmental governance in Scotland, as well as Scots' right and ability to take action on the environment. I also think a more detailed definition of environment would be valuable. Finally, I am clear that the further scrutiny of Schedule 1 and exemptions in paragraph 1.2 is essential. The committee raised these concerns in a recommendation 180. The Scottish Government response was detailed and helpful, but if the exception in Schedule 1 is required for accounting or other general reporting requirements, could the clause be more tightly drawn to allow for that exception but no others? I still argue that the scope of the exception is too broad. Finally, I support the principles of the bill along with our committee and Scottish Labour, and I look forward to working with all to take forward the best continuity bill possible. Thank you.
Thank you. I call John Mason to be followed by Alexander Barrett.
Thank you very much, Presiding Officer, for the opportunity to speak today. Firstly, can I say that Scotland wants to trade freely with both the UK and with the EU? And I fully accept that the UK may be the bigger part of that trade. And of course we do not want to lose that 60%, but neither do we want to lose the 20% with the EU. What country in its right mind would put 20% of its exports in jeopardy? So the main aim of this bill is to keep us aligned with both the UK and the EU. It would seem wise for us to keep our environmental and other standards as closely in line with the EU as possible, and that should make it easier for us to trade with them, and it should make it easier when we re-enter the EU as a free member in our own right. One of the first questions we faced in the Finance Committee was whether we needed this legislation at all. It was suggested that primary legislation could be used for every issue. However, I think we accepted that this would be impracticable and minor tweaking of existing policies would be best dealt with by secondary legislation. Following on from this was the need for guidance on what criteria there would be for the Scottish Government using these powers. I think it is agreed that guidance is required by the Government, but the Government does not consider that an amendment to the bill is needed. They are committing to providing guidance, and I guess we will go into that in more detail at stage 2. Another suggestion was that it should be mandatory for ministers to keep pace, at least on environmental matters. This was suggested by the National Trust for Scotland and by Scottish Environment Link. Clearly, they trust the EU more than they trust the UK, and I myself share that position. However, I take the Government's point that the power needs to be discretionary, as it would just not be possible to keep pace with everything. Again, there is the question of volume of work involved in keeping pace both for the Scottish Government and for Parliament. And I'm not sure it would be practicable to require the Government to report on every single EU law that is not being kept pace with. It is probably not possible to examine every decision to keep pace or not, but I do think Parliament, through the committees, should be ready to challenge the Government as to why any particular directive is not being followed. I have to say I'm quite drawn to the idea of an annual report from the Scottish Government, looking at EU legislative priorities for the coming year, as well as looking back at what has already been done. And I think the Government is agreeing to this. The DPLR Committee considers that for major new policies, in contrast to amendments to existing policies, primary legislation in this Parliament will normally be the best way to go. I think the Government accepts this, talking about, quote, areas of major innovation, unquote, so that is good. However, I note that the Government seems reluctant to have amendments to this effect on the face of the bill, apparently because they would be difficult to word, and I guess that is a challenge for somebody to propose suitable amendments which the committee could consider at stage 2. The relationship with the UK's internal market bill is also relevant. If, as we fear, that bill allows the UK Government to roll back devolution, or at least gives power to private companies to challenge devolution, then the scope for us to align with the EU may be more limited. But again, the key point is that we want Scotland to be outward-looking and international, not narrowly focused on the British or English market, important though that is. We also touched on common frameworks, and they will hopefully be voluntarily entered into by all the devolved administrations. And if that is the case, it is to be welcomed. But bargaining between governments in a private room late at night or over the phone, as we know has happened before, does not make scrutiny by this Parliament, or for that matter by the Westminster Parliament, very easy. The Scottish Government confirms in its response that there should be, quote, an appropriate role, unquote, for Parliament, and it would be good if we could hear more detail on that in due course. So overall, I believe we can support this bill in principle, and I hope members will do so at decision time. Thank you.
Thank you very much. Before I call Alexander Burnett, can I remind members who are taking part in the debate to press their request to speak buttons in good time to be called. Alexander Burnett, to be followed by Kenneth Gibson.
Thank you, Deputy Presiding Officer. Now, just yesterday I was glad to contribute to a debate that focused on how to support the Scottish energy industry in helping meet our climate change targets and improve energy efficiency. As a member of the Scottish Parliament, I take pride in doing what I can to represent my constituents and take part in debates which will bring real positive change to their life and the next generation. But today I'm wasting time I could have spent helping constituents by debating a bill which has only one underlying aim: to reopen old division and break up the country in the middle of a pandemic. As a member of the Finance and Constitution Committee, it is on record that I dissented from supporting the general principles of this bill. And I did so for a number of reasons. Because whilst the divisive aim of the bill is plain for all to see, and whilst Mike Russell and his colleagues choose to devote valuable time in the midst of a pandemic to such legislation, it is, as usual, flawed. Firstly, because this bill will lead to a lack of scrutiny, and that is simply not good enough. The policy memorandum states that apart from some prescribed circumstances set out in Section 4 of the bill, negative procedures will be used to align with EU law. This will lead to this Parliament's role being diminished, as there is no scrutiny when EU law is simply copied and pasted into Scots law. And Professor McHarg raised concerns, noting that the lack of scrutiny arrangements in this bill are even weaker than the scrutiny arrangements the SNP proposed in their original UK Continuity Scotland bill. But not only that, our committee pointed out that the Scottish Government has admitted it is not possible to keep pace with all future EU laws. And the committee recommended that amendments should be made to the bill that set out guidance on how the keeping pace power would be used. The Law Society of Scotland agreed with this recommendation, and so I hope the SNP will be wise to change the habit of a lifetime and listen to these organisations. But I cannot support a bill which fails to recognise the importance of our biggest trading partner, the United Kingdom. 60% of our trade is with the rest of the UK, worth over £50 billion. NFU Scotland repeat this point, noting how the UK internal market is far more important to the interests of Scottish agriculture than the EU market or other export markets. Now, The bill's policy memorandum also states that the Scottish Government will do everything it can to be an active and constructive participant on EU matters. What a pity it is, then, that the SNP can never bring themselves to be active and constructive on UK matters, which have far greater impact on Scotland's interests. But this bill is simply another opportunity for the SNP to reheat their separatist agenda. The coronavirus pandemic has shown that we have had to adapt, and now, more than ever, we need to work with the rest of the UK and take advantage of the benefits that being part of this union brings. This Parliament's time would be better spent discussing ways we can create jobs, become world leaders in education once more, and drive forward the revolution we need to see in tackling climate change. Perhaps one day this Parliament will stop being used as a tool for separatist grandstanding and focus on shaping a better Scotland for future generations. Thank you.
Thank you. I call Kenneth Gibson to be followed by Stuart McMillan, who will be the last open debate speaker.
Thank you, Presiding Officer, and that's a really hard act to follow. In 2016, Minister for the Cabinet Office Michael Gove MP said, and I quote, "There is a free trade zone stretching from Iceland to Turkey that all European nations have access to. After we vote to leave, we will remain in this zone." And former Tory MEP and founding member of the Vote Leave campaign, Daniel Hannan, declared, "Absolutely nobody is talking about threatening our place in the single market." Indeed, the current Prime Minister promised in the aftermath of the Brexit vote that Britain would retain access to the single market. How times and Tory policy has changed. And the risk of Scotland crashing out of the European single market without any trade deal whatsoever has never been greater than it is right now. Who knows, the UK Tory government might strike a very limited last-minute low deal with the European Union, only marginally less damaging than no deal at all. As a third country, many goods entering Scotland from the European mainland would still be subject to border checks, which, by the UK government's own admission, will lead to delays as well as an increase in cost and bureaucracy for our businesses. Presiding Officer, the people of Scotland did not vote for any type of Brexit, and most certainly not for the cliff edge scenario we face in only 2 months' time in the middle of a pandemic. A direct consequence of this is that a majority of Scots now want our nation to be an independent country. We could then rejoin the European Union and its single market of 450 million people. In the meantime, it's our duty to prepare for this by staying close to our European partners. The Continuity Bill will be a helpful instrument in allowing our businesses to keep pace with European directives and regulations where it makes sense to do so. Happy to take an intervention.
Dean Locker.
Thank you very much. Mr Gibson talks about Scotland rejoining the European Union. Can he tell us how his government will reduce Scotland's fiscal deficit, which is currently around 25% of GDP, to the 3% requirement required by the EU?
Kenneth Gibson.
I have to say it's quite shocking the kind of union dividend that Scotland has been subjected to. What Mr Lockhart seems to believe is that Scotland is some kind of parasitic nation in which we live off the rest of the United Kingdom. We all know very well that the UK government is inept when it comes to actually developing and growing Scotland's economy and indeed making sure that we are a country that's able to play a full role in Europe. The UK dividend, 2 million people migrating out of this country from 1950 to 2000. That's your union dividend, Mr Lockhart. In the meantime, it's our duty to prepare for this, the current Brexit situation by staying close to European partners. At a time of huge economic uncertainty, this bill will also provide businesses in Scotland and the EU with vital consistency and predictability. I therefore also welcome the Scottish Government's willingness to prepare regular reports about the EU's upcoming legislative priorities and updates on how they may affect Scotland's devolved competencies. Yet this is about more than just economics. The Continuity Bill will also help us uphold the EU's core values and principles, which we share. I'm pleased the bill seeks to maintain or enhance the EU's high environmental protection standards after the Tories drag us out of the single market, customs union and the European Court of Justice's jurisdiction. As a country, we have world-leading ambitions when it comes to tackling global warming and will never accept a post-Brexit race to the bottom in environmental standards. I welcome the fact that this bill seeks to establish a robust and independent environmental governance body, Environmental Standards Scotland, to secure full and effective implementation of environmental legislation. Of course, the current devolution arrangement between the Scottish Government will only have discretionary powers to maintain alignment in matters devolved to the Scottish Parliament. Sadly, even in these devolved policy areas, the UK Government's unacceptable internal market bill poses a serious risk to our ability to maintain close alignment with the EU standards where we choose to do so. I share the Finance and Constitution Committee's concerns that the use of the keeping pace power in the Continuity Bill may still be undermined by the internal market's market access principles. Its implementation could force us to accept lower food or environmental standards set elsewhere against the explicit wishes of the Scottish Parliament. Presiding Officer, the Continuity Bill is clearly a helpful and necessary instrument in reducing the economic shock of a no-deal Brexit. It allows us to maintain close alignment with European Union standards in devolved areas when we consider it appropriate and practical to do so. Yet the UK Tory government's disastrous internal market bill also makes it clear that, as long as we are part of the United Kingdom, decisions taken by the Scottish Parliament will be at constant risk of being overruled by Westminster.
Thank you, and I call Stuart McMillan.
Presiding Officer, I welcome the Continuity Bill, and I know that local constituents certainly welcome it too. And actually taking action now to protect the future is crucial, to protect the interests of people, businesses, but also our environment. I had a discussion with a constituent last week who genuinely was raising concerns about what's going to happen to our regulations in a post-EU environment. And when I told her about this bill and the purpose of this bill, and my constituent genuinely was pleased to hear it. They were keen to learn that this Parliament was determined to focus and also work for the interests of every single person who lives here. Although the UK has taken the decision to leave the EU, even though Scotland didn't, it's vital that this Parliament does what it can to keep our standards as high as possible, aligning with our European neighbours, instead of the race to the bottom as proposed by the Prime Minister and also the Tory UK government. Also, I thought it was actually very telling that in the session just prior to this, when MSPs from across the chamber were asking Richard Lochhead questions regarding the impact of Brexit on Scottish further and higher education. Now, the issues of Erasmus, research funding and also international researchers were key points, and genuinely it was MSPs from across the chamber. So and these were genuine questions that members were putting forward. So I do find it quite strange that Edward Mountain's comments a few moments ago, just regarding, sorry, not Edward Mountain, sorry, Alexander Burnett. I do apologise. But I do find it certainly very strange, Alexander Burnett's comments a few moments ago, when just attempting to portray this particular bill as some type of grievance bill. It certainly is not. This is a bill to actually try to protect and help our population and also some of the services within Scotland. I think the bill in front of us, however, does become even more important as a consequence of things that have happened. The proposals in this continuity bill are based on the existing strong institutional arrangements for climate change action, including the role taken by this Parliament and also the Committee on Climate Change. And our climate change legislation, as agreed by the Parliament in 2009 and also 2019, provides a strong role for regular independent expert advice from the UK Committee on Climate Change, and also in addition to our ambitious headline targets for net zero emissions by 2045. We're also the only country to have legally binding annual emissions targets, meaning that reporting to Parliament and scrutiny of progress happens every single year. I thought that submission from the Faculty of Advocates and their submission to the Environment, Climate Change and Land Reform Committee call for evidence on the 31st of July 2020 was very helpful. And I quote, after the end of the transition period, some areas previously subject to EU regulation will continue to require regulation at a domestic level in the interests of good government. Within those areas, the subject matter may pertain to an area within devolved competence. A power to adopt EU measures appears to us to offer a vehicle for such necessary regulation of those areas in future. Now, I believe Brexit should not mean a race to the bottom on environmental standards, which is why the Scottish Government is absolutely correct to keep pace with EU regulations. In addition, the UK Government, the UK is already facing the worst economic crisis in decades, and yet the Tories are still determined to crash out of the transition period this year, imposing yet more uncertainty on Scottish businesses during a global health emergency. And then add in the social and economic effects of COVID-19 in Scotland, then it's essential that some degree of certainty for our population takes place. So until such times as we become an independent country, it's important that this Parliament maintains an international outlook, and this bill does that within the limited areas that it considers. Thank you very much.
Thank you very much. We now move to closing speeches, and I call Sarah Boyack to be followed by Murdo Fraser.
Thank you very much, Presiding Officer. Well, I think this has been a really important debate this afternoon. We need this debate but it's clear from the hard work of our committees that it needs to be improved and that the Scottish Government should commit to support a more accountable approach to keep the democratic principle of important policies being tested by Parliament, not just Scottish ministers. Now, I did agree with Liz Smith's comments that both governments need to work together, but the UK Government needs to respect our devolved governments and international law, so it's really striking how out of step the Tories have been in their speeches today. This bill is even more important to ensure that we retain the high environmental standards that our country needs, and that was supported by speakers across the chamber. And this debate gives us the opportunity to ensure that the powers of this devolved Parliament are able to maintain what are currently some of the highest levels of environmental standards in the world and to keep pace with improvements in standards in the EU. But it also gives us the opportunity here to decide what standards we wish to maintain in Scotland as Brexit pulls us out of the EU, creating huge economic uncertainty in the middle of this pandemic. So the comments by Alexander Burnett were completely bizarre and somewhat ironic. Part 2 of this bill sets out the framework for keeping pace with EU environmental standards, and as Alec Rowley made clear, Scottish Labour welcomes the proposal in this bill of a new environmental governance body, but we do believe that this body needs to be independent from the Scottish Government. Now, as several colleagues have mentioned, climate change, individual cases and fiscal measures should all be included in its remit, and exemptions to investigations should be prevented, at least to have to go through primary legislation. And I think we should take on board the evidence from Scottish Environment Link, who've argued that the exemption of individual decisions overlooks the critical role that individual decisions have had in setting precedents in the past. So we welcome the fact that EU guiding principles are incorporated in the bill, but as we argued in the previous debate continuity bill, Claudia Beamish rightly said this afternoon, we can still do more to strengthen this bill with better recognition of human health impacts and environmental protection. And we also feel, having looked at the evidence, that as some future changes in EU law could involve substantial policy considerations, this Parliament and our stakeholders must also have the opportunity to scrutinise and influence the law as it will apply in Scotland. So we believe that in principle new powers should allow the Government to keep pace with EU laws, and we should be able to deliver strong environmental standards that we want to see in Scotland. But it's absolutely crucial that we ensure that there's transparency and accountability. And we think there are changes that need to be made before this bill comes back to us at stage 2. And I hope that in summing up, the Scottish ministers will commit to look at these issues. They've been raised by 2 committees. There's clear cross-party support for it. And it's really important that we have the democratic accountability and the principles so that people who make representation to this Parliament can see the transparency, their views have been considered, and so that the points that I think were made across the parties about the importance of tackling climate change, biodiversity, making sure that we've got strong environmental policies, this is critical that in our future economic and trade relations, we have strong standards in Scotland because that's what we want, and it's important that our Parliament debates those issues, our Parliament debates the detail, and while we work with ministers, it's the Parliament that needs to do that work, advised by ministers, but not just without the control of this Parliament. I think that's a really, really important principle. So I do want to thank the committee members for the work they've done so far. I hope ministers will reflect on the power of their scrutiny and work with MSPs to deliver the change we need to see to strengthen this bill, because it couldn't be more important at this time as we look at Brexit coming down the track. This bill is important for the future of Scotland. Thank you.
Thank you, Murdo Fraser, to be followed by Michael Russell.
Thank you, Deputy Presiding Officer. Can I remind members that I am a member of the Law Society of Scotland, as I will be referring to their evidence to the Finance and Constitution Committee. Now, as we've heard throughout this debate, what this bill does is seek to give Scottish ministers the power to keep pace with EU legislation. But this will apply after we've left the EU. So we're talking about laws being made by another supranational body of which we are not members and to whom we have no direct relationship. So the laws we're talking about are laws being made by others in relation to which we have had no input. And what this bill does, as a number of witnesses to the Finance and Constitution Committee made clear, is put Scotland in the position of being a rule taker but not a rule maker. And there were widespread concerns about this approach expressed to the committee in evidence. Now, one example was quoted by both Dean Lockhart and Liz Smith in the debate, and that's the evidence from the National Farmers Union of Scotland, who are concerned that Scottish producers could be put at a competitive disadvantage if they are obliged to adhere to an EU regulatory framework for the environment insofar as it relates to agricultural practice, where producers elsewhere in the UK are not, because this, in their view, causes distortion within the UK internal market, by far, of course, the biggest market for Scottish agricultural exports and the primary source of the majority of agricultural inputs. And that's not the only thing wrong with the bill before us. A whole host of witnesses to the committee, including Professor Aileen McHarg, Professor Michael Keating, the Faculty of Advocates, the Law Society and the NFUS, all expressed concerns about the sweeping powers being given to Scottish ministers under this bill. So laws made in the EU, laws in relation to which we have had no input, will be introduced to Scotland by Scottish ministers with very limited parliamentary scrutiny and no scope for amendment. There is, in a second. Now, there's one term for this, presiding officer, and that is a power grab. That's a term the Constitution Secretary is very familiar with, and it's a real irony that he's now guilty of the very act he continually complains that the UK government is doing. The reference I made earlier in intervention to the Henry VIII powers was a direct quote from Professor Tom Mullen, the advisor to the Finance and Constitution Committee, an eminent constitutional lawyer who Mr Russell complains is patronising the Chamber with his view. I suggest that Professor Mullen knows more about these matters than Mr Russell does. And Mr Harvey wants to come in at this point.
Patrick Harvey.
I'm grateful to Mr Fraser for giving way, and I'm sure he wasn't intending to suggest that the list of witnesses he cited were all calling for this bill to be abandoned, because that certainly wasn't their position. But the Tories argue that this will open up a divergence, a regulatory divergence with the rest of the UK. That cannot be the case if he accepts the UK's promise not to diverge from or water down EU standards. So which is it? Does he agree with the UK government, or does he think there's regulatory divergence?
Murdo Fraser.
Really false choice for Mr Harvey. We don't know what the EU is going to do in future. We know that in many areas, UK regulations are actually stricter than EU laws. But we don't know where the EU is going to go in future. And to suggest we adopt a blanket approach to adopting every single EU law, whether we've been consulted on it or not, would put Scottish farmers at a competitive disadvantage, which is precisely why the NFUS are concerned about the bill before us. And as the committee heard time and time again, presiding officer, if the government wants to bring in major new policy changes, it has a mechanism to do that, the tried and tested mechanism of primary legislation, because that allows for full consultation, discussion with stakeholders, proper impact assessments to be done, and it also allows for this Parliament to amend the legislation, which does not apply in the case of the secondary legislation that this bill sets up. So, presiding officer, there was an opportunity to approach this whole issue differently. There was an opportunity for the Scottish Government to bring forward a piece of legislation that would allow minor tweaks to existing EU laws to be done via secondary legislation. And I do not think anyone would have objected to a bill that said that. But what we have today is quite different. It gives sweeping powers to Scottish ministers. It will seek to align Scottish law with the future law of the EU, a body of which we are not members and will not have a direct relationship. It will be damaging to Scottish business, as Dean Lockhart has said, and to vital sectors like agriculture, and for all these reasons, it should be rejected. Presiding officer, just to conclude, what we have before us is bad law. There could have been a consensus about the way forward that would have got the support of stakeholders, and that was to bring in a law allowing ministers to make minor adjustments to existing legislation by use of regulation. Instead, what we have is a power grab by Mr Russell, the Henry VIII of this parliamentary chamber, presiding officer, a power grab that will damage the Scottish economy, a power grab that disrespects this Parliament and takes power away from it, and one which is fuelled by this SNP government's ideological obsession with the EU. And for all these reasons, Parliament should reject the bill before us. Thank you.
Thank you. I now call on Michael Russell to wind up this debate. Cabinet Secretary, you have until 5:05.
Thank you, Presiding Officer. Let me start with the positives in this debate and to say to the other parties, with the exception of the Conservatives, I think my opening speech was very clear. that I want to debate and discuss some of the key issues that the committee has identified. I think there are areas, and this has been my approach to every bill that I've ever brought to this chamber, that this bill can be improved and developed, and we will find a way to do so. I note the points that have been made by a variety of members across the chamber. I think the Stage 1 report has some very important issues within it which we can respond to from all the committees, and we will do so. We won't agree on everything. One thing that's common across every bill I've ever been involved in is that there is always a debate and a discussion about the levels of subordinate legislation, a matter which actually to most people outside this chamber seems entirely arcane, but I know it is very important to members of this chamber, and I think we're going to have that discussion and dispute, and I think we will find a way through it. But what I want to reflect upon in the few minutes I have available to me is the extraordinary speeches from the Conservatives. I think Sarah Boyack used that word, and she is quite right to use it. Let us start by remembering why we are here. This chamber passed by an overwhelming majority a continuity bill. It was a bill that had keeping pace powers. And that bill was, with one very, very small exception, not in this area, entirely within the competence of this Parliament. And the UK Conservative government changed the law to outlaw that bill. That is what the Supreme Court found. They changed the law to outline that bill. So we are here repeating what we have done because the UK Conservative government, backed by a minority in this chamber, managed to overrule a piece of legislation which had been passed by an overwhelming majority. So that is why we are here. And in addition, we are here, I would say to Mr Burnett, we are here using the valuable time that he would spend with his constituents because of the UK Tory government. So I hope he will take this issue up with his colleagues in the UK Tory party and blame them for the fact that we are having to come back here. And he should blame them for something else too. Mr Burnett has talked about the waste of time and money that Brexit has been. Oh, indeed, I agree with him. I agree with him to the tune of £200 billion, which has been the cost of Brexit. I agree with him because I have spent a great deal of the last 4 years engaged in this, and I would much rather I hadn't been, because the people of the country in which I live voted against Brexit. And I have had to spend that time, as we have all had to spend that time, on something against the wishes of our constituents. So please don't remind me of the waste and time. Go on and remind your Conservative colleagues. Now, I have to say that I have a life full of enjoyable instances and excitements. And I go straight from this debate today to a meeting of the JMC-EN, in which I shall no doubt hear many of the same arguments put by the UK Tory party. And it will allow me a further opportunity to wonder, as I have spent this afternoon wondering, at the current state of the Tory party. Mr Lockhart's contribution reminded me of that line, I think, from Alice Through the Looking Glass. If I had a world of my own, everything would be nonsense. Because he was living entirely in a world of his own. It is a completely upside-down world in which he is living. No, thank you, please. I am standing the right way up, and I am going to continue. I am going to continue on that matter. So allow me to deconstruct the nonsense that I heard earlier this afternoon. And there are three particular items that I will deconstruct. The first one is, and I have to raise this point because it is a point for this chamber of great significance. Twice now, Mr Lockhart in this chamber has contended that the Internal Market Bill bases its powers upon the frameworks and is there to support the frameworks. The official report will make it entirely clear. It's happened twice now, happened in a previous debate. And at that time, I asked Mr Lockhart to correct the official report because it was not true. The bill does not refer to the frameworks in that way. And he repeated it this afternoon. He doubled down on an assertion about the Internal Markets Bill, which is not true. And that is a very serious matter, because this bill is of enormous... No, I want to finish this point, and I'll give way. This bill is of enormous importance. It is taking powers away from this Parliament, and we must tell the truth about it. Please, Mr Lockhart, tell the truth about it.
Dean Lockhart.
Well, this is a debate about the EU Continuity Bill. Can the Cabinet Secretary respond to comments made by European Union officials that said this legislation wouldn't be effective and it would be difficult to implement and will not apply to Scotland? That's not from us. It's not from the UK government. That's coming directly from the European Union.
Address the issue of the Internal Market Bill. I have given him the opportunity. I've given him the opportunity to correct something that was said twice in this chamber and has not been corrected. Let the record show that. Now, the second issue that we have here is very important, because the issue of jobs and the retention of jobs. And the argument from the Conservatives has been, all afternoon, that in actual fact, high standards cost jobs. That has been the argument we've heard. And the argument is, if you lower those standards, if you become a deregulator, because that is what the argument is, then you will create jobs in Scotland. It is not true. It is utterly counterproductive. It is throwing away all the advantages we have in order to create jobs, and they won't be created, because they simply won't be created. So that is also an area in which the Chamber has been woefully misinformed this afternoon. But then there is a third and very significant point, and it is this: the issue of being a rule taker. How can any Conservative, with the Internal Markets Bill in front of them, the most massive undermining of devolution since the start of devolution, don't take my word for it, take the word of Lord Hope, the former Deputy President of the Supreme Court, take the word of the Anglican primates across these islands, take the word of any of those members of the House of Lords who have spoken upon it in these matters. Take their word for it. And yet, apparently, that is not true, because Mr. Lockhart says it isn't true. A rule taker. A rule taker. That is what, that is what the Conservative UK government is seeking to make this Parliament, to take away our powers to do things, to take away our powers to make rules and to undermine them. So I just have to say, after this debate, the state of the Scottish Conservative Party is woeful. It is utterly woeful, but it is worse than woeful, because what we've heard this afternoon is an attempt to defend the indefensible. This bill we are debating because the previous bill was sabotaged by the UK Tory government with the consent of the Tory party in Scotland. And now, black is white and white is black. I am grateful for the members across this chamber who have shown their commitment to take this bill through. We will take this bill through, but it will be part of a process of saying to the people of Scotland, we have the right in Scotland to make our own choices about what we do. And we will not be told not to do it. We will not be cheated out of it by people who care nothing for this chamber and everything for their colleagues south of the border. It is a shameful position, and it will not stand.
Thank you very much. That concludes our debate on the UK withdrawal from the European Union Continuity Scotland Bill. Point of order, Jamie Green. Mr Green.
Thank you, Presiding Officer. Yes, it is a real one. Thanks for asking. On Tuesday, this Parliament very rightly debated the Scottish Government's plans for a new tiered approach to tackle COVID. And I'm really pleased that the motion received cross-party support for these important measures. And today, shortly before First Minister's questions, the Government announced a list of tiers which our own respective local areas will fall into. From next week, these new tiers will place restrictions on many millions of people in our constituencies and regions, and many thousands of local businesses will be affected by it, including Inverclyde in the region that I represent, which was placed into Tier 3, despite all of its current indicators being at levels 1 or 2. People rightly have questions of us, and we as MSPs rightly have questions of the government. I would appreciate if members listen to the point I'm making. Thank you.
Let us hear the member make the point of order. Let us hear the member make the point of order.
Presiding Officer, I do appreciate that you extended First Minister's questions today to accommodate questions from members, and I also appreciate that the First Minister expressed willingness to take as many questions as she could, and I thank her for that. But by the close of that session, many members in this chamber, including those from the government benches, still had important questions to ask of the government for the measures which will be introduced. We now will not get the chance to ask the government important things before they take place on Monday. Can I simply ask, Presiding Officer, what additional steps you, as the Presiding Officer, or the parliamentary officials will take to ensure that when these announcements are made, that every member of this Parliament has a legitimate right to ask or raise concerns, that they will be given the opportunity to do so? Because that is the least that we can offer those affected by the decisions that we make in this place.
Thank you very much, Mr Green. And these matters are very much a question of procedure for the Chair, or more likely, though, for the Bureau. The point the member makes is actually very similar to the point of order made by Joanne Lamont following FMQs. What I would suggest is that the Bureau is actively considering the process of scrutiny of COVID-related response. The current process is the Government proposes a programme to the Bureau, and the Bureau agrees that programme and proposes it to the Parliament. The Parliament then votes on the business programme and allocates time. So it's very much in the members' hands about how much time is allocated to allow scrutiny and questions for scrutiny. This subject will be on the agenda on Tuesday. I would encourage the member, in fact I would encourage all members to speak to their business managers if they don't have enough opportunities to put questions or would like to the opportunity, for example, to attend committees or others to improve the scrutiny process. And I hope that addresses the member's point. A point of order, Neil Findlay.
Presiding Officer, Mr Green and Joanne Lamont raised very pertinent points here. And if government backbenchers don't like it, then that is tough. We have got every right to raise questions, raise points on the floor of Parliament on behalf of our constituents. The issue that we have is that these new impositions have been brought in before members have any opportunity to ask questions about them. And I appreciate your saying that these things are being discussed, but we've been raising these issues for 8 months, and they continue to be discussed. New laws, new guidelines, new regulations are brought in, affecting hundreds of thousands, millions of people who are ramming our inboxes every day, raising questions about a whole range of issues. And we do not have the opportunity to thoroughly scrutinise what the government is doing before these issues are implemented. That is the key point that people are raising.
Can I thank Mr Findlay? Can I thank Mr Findlay? I don't want to prolong this. I would just put it to Mr Findlay, this Parliament and the UK Parliament have both passed laws which give the government executive authority to act urgently to bring in force emergency measures, which is why the government made affirmatives. These matters, however, are causing some concern amongst a wide variety of members and the general public, and that is why they are on our agenda right now. I would merely suggest to all members that if they have views on this matter, to bring them to the attention of the Bureau through the business manager, and we will discuss this matter, and hopefully we'll be able to move matters forward in a constructive manner. Thank you. So we'll move on to the next item of business, which is consideration of motion 22723 on the UK... Oh, sorry. I have to move the financial resolution first. Yes, it is. That is, yes. So it's consideration of motion 22723 on the UK withdrawal from the European Union Continuity Scotland Bill financial resolution. Could I call Ben Macpherson to move this motion? Thank you very much indeed. That's moved. So we turn to decision time when we will vote on these measures. The first question is that motion 23163 in the name of Michael Russell on the UK withdrawal from the European Union Continuity Scotland Bill be agreed. Are we all agreed? Yes. We're not agreed. We'll move to a vote. Now, as members know, we will have to allow all members to access the voting platform, including those online. So I'll suspend Parliament for a few moments to allow members to do exactly that. Parliament is suspended. Thank you, colleagues. We are now back in session. We're going to go straight to the vote. The question is that motion 23163, in the name of Michael Russell, on the UK withdrawal from the European Union Continuity Scotland Bill be agreed, and members may cast their votes now. This will be a 1-minute division.
My son got it. I got it. My son got it. You see,
And that vote is now closed. If any members do not think they have voted, please let us know, either through a point of order or online. Can I call Ash Denham to make a point of order? Ash Denham to make a point of order.
Thank you, Presiding Officer. I was unable to vote this evening due to a technical issue, and I would have voted in favour.
And did I hear that you would have voted yes on that motion?
That's
yes.
correct.
Thank you very much, Ms Denham. I'll make sure that your name is added to the voting roll. Thank you. Thank you, colleagues. The result of the vote on motion 23163 in the name of Michael Russell is yes 87, no 27. There were no abstentions and the motion is therefore agreed. And our final question is that motion 22723 in the name of Kate Forbes on a financial resolution to the UK withdrawal from the European Union Continuity Bill be agreed. Are we all agreed? Yes. We are agreed. Thank you very much, and that concludes decision time. I close the